Funding for Books at the Berkshire is provided by the Berkshire Grill in Seattle's Northgate neighborhood. Local flavor and local value served with a touch of culture. And by Verity Credit Union, serving Washington communities from locations in Northgate, Alderwood, and Beacon Hill. And by Pavin and Riley and Avery Lane Wineries, when quality is your destination. And by Getz Meats, proud to support the Northwest community. And by Tony's Coffee. And by the Delta Society. Additional funding for Books at the Berkshire is provided by these proud sponsors.
Hello, and welcome to Books at the Berkshire, where we bring you thoughtful conversations with local authors on topics of interest to our community. Neighbor disputes, road rage, rudeness in public, cyber stalking. It seems that incivility abounds in our society, that social interactions are becoming harsher, and that manners and etiquette have gone by the wayside. Are we losing our civility? Or has the daunting task of getting along with our neighbors always been this difficult? What should we do about it? Do we need laws, lawsuits, and the manners police to help ensure good behavior? Or are there other options? Our guests today have examined these troublesome questions in their new book, Seeking Civility, Common Courtesy and the Common Law. George Jarecke and Nancy Plant are attorneys who have researched case upon case of misbehavior by supposedly civil people, and are here to share some of their conclusions and observations with us. Welcome to Books at the Berkshire, Nancy and George.
Thank you, Walter.
Thank you, Walter. It's nice to be here.
It's good to have you here. It seems that when you talk to people today, everybody has a story to tell, whether it's smokers, drivers, landlords, tenants, clerks, customers. It seems that people are just getting ruder. Is this really the case? Is this something new, or is this something that's always been with us?
Well, we had that sense as well, Walter, before we began looking into the book, that somehow we were finding ourselves more and more irritated just getting through the day with people in the grocery line, people at the stoplight, whatever. When we started to look into the legal remedies that people use when they feel they've been very rudely treated, we realized that they in fact have long historical roots, and that many of the actions, the civil actions that people bring in these kinds of cases, date back to the English common law that was brought over to America, and that are the roots of our law.
So rudeness isn't necessarily a new phenomenon. It's something we've been dealing with for a long time. Now, in your book, you talk about torts, and this is a legal term for the kinds of actions that people bring in these sorts of cases. Can you tell us a little bit about what those are and what kinds there are and how they work?
Well, a tort, Walter, I guess just a simple definition is it's an injury independent of contract. The oldest kinds of wrongs, as we looked at in the book, are simple ones that we know in society: battery, trespass, nuisance, which is another type of property tort. So it's a very simple thing. It's simply an injury that occurs independent of a contract.
Now, some of the things that you're talking about sound like crimes, but I understand a tort isn't a crime.
That's right. A crime is when a criminal prosecution occurs when society's rules have been violated, and society, in the form of the government, prosecutes an individual for violating those rules. A tort is a civil action between two individuals. So the government is there only in the form of the judiciary, which acts as the arbiter of the dispute, but the government is not prosecuting the tort in any way. It's one person complaining of a wrong that another has done to him or her.
So if I feel that someone's rudeness has just set me off the wrong way or gone beyond the bounds of what I'm going to stand for, I can bring a tort action against somebody on some of these legal grounds. What's an example of the kinds of case that you looked at in this book? There were numerous, but a typical one that's a good illustration of this kind of action.
Well, I suppose one of the one of the best that one of the ones that we found most interesting and perhaps one of the most outrageous was a nuisance action out of Maryland. It's not a particularly new case, but it was the case of a family that became very annoyed with their neighbors and put a radio in the window and set it blasting day and night, so that the people next door didn't get any peace at all. This went on for years and years, actually, until the neighbors finally had had enough of it and brought suit.
And this was a deliberate action on the part of the neighbors to put this wasn't just loud parties.
Oh no, they certainly meant to do it, and despite the neighbors complaining, they continued it.
And in fact, they had to make accommodations in their own home. They moved their kids to the other side of the house so they wouldn't have to listen to the radio, to be sure that the radio would annoy the neighbors but wouldn't annoy anyone in their own home.
Well, this is clearly rude behavior. I think everyone would agree to that. This went on for how long?
A number of years.
Wow. And was there remedy found for this through the tort action?
Yes, this was a nuisance. The court found, the court instructed the jury, and the jury found that this was an interference, an unreasonable interference with the ordinary enjoyment of their property, which is all you have to have for a nuisance.
But you can't help, in reading that case, I think, wonder how it came to pass that case ever had to come to the legal system at all. I mean, you would hope, years and years of blasting a radio at your neighbors, that there would be some other way to resolve that dispute rather than ultimately the neighbors having to sue. I mean, couldn't another neighbor have intervened, perhaps? I mean, you would want your community to help you handle those kinds of disputes. But in this case actually occurred back in the 50s, which is sometimes idealized as a time when we had these great communities. But none of those things happened. The neighbors who were the victims of this tried to talk at least once to the family that was that had the radio on, and that didn't work either. So they were left with essentially no remedy but to sue. And they got justice in the end, but there's something frustrating about the whole process, that the thing happened to begin with and that there was no way to shortcut it before it got to the legal system.
That's an interesting point that you bring up, and you talk about this in the book as well. And you mentioned earlier that some of the principles for these torts are very old, the ones that you mentioned, battery and nuisance and trespass, a lot of which involve property rights or personal body rights. Mm-hmm. These go back to the Anglo-Saxon law. What does that say about our human nature that we have set up these kinds of legal remedies for this in our tradition, but there doesn't seem to be anything else in our tradition to address these?
Well, I think it perhaps speaks to the Anglo-American love of personal rights and the protection of personal rights, as opposed to another culture which may have more of a sense of the community working things out amongst itself, or even subordinating one's own needs and desires to the needs and desires of the community. I think those two of the very simple torts tell you a lot about that. The battery is very simple. That's simply an unwanted or offensive touching, and the person who's touched doesn't even have to be injured. But what the courts wanted, was the person who suffered the injury not to take retaliation, but to bring the lawsuit instead. Same thing with the trespass. All I have to do is walk across your property, and I've trespassed on it. I don't have to trample your tulips or kick your kids' toys. I just have to walk on your property. And if I've done that without your permission, I've trespassed, and you can bring an action against me even though you haven't been injured. Again, the court doesn't want you shooting me. The court wants you suing me.
I see. So the legal remedy was there to take the place of some other, perhaps more drastic personal remedies that we as individuals might have taken against each other where there are no laws. It's interesting, though, that all of the concepts that you discuss are related to the rights of usually a property owner or the rights of an individual. Do we need more of an emphasis on community rather than individual rights to try and put some of these conflicts into context?
Yeah, I think there's something to be said for that. There's a lot of talk these days about community and how we're lacking a sense of community. And as we've sort of touched on, it's not clear whether that problem has gotten better or worse. I mean, it may be that it's always been that way to some extent. But part of the problem is you don't have people, as George was saying, subordinating their interests to that of the community. The timing of writing the book was such that we completed it shortly after the September 11th tragedy. And one thing we noticed after that day was that there seemed, for a short time anyway, to be a greater sense of community. And the minor things that people do to each other, that annoy each other, seemed to be much less important. People had a greater sense of us as a country and what we faced and what we had in common. And somehow we had hoped that that spirit might be sustained in a way, so that we would focus more on the important things and less on the kind of minor incivilities that lead to lawsuits and other use of society's resources.
Do you think that's occurred, George?
Again, I agree with Nancy. I think it seemed to have for a while. There seemed to be a lot in the papers, a lot of anecdotal evidence of people letting people merge on the highways a little more easily and things like that. But now it seems, in fact, to be somewhat worse, if anything. And perhaps some of that's attributable to the political divisiveness that we find in the country as well.
Yeah. Certainly, it doesn't seem that our valuation of individual rights has diminished any recently.
That's an important point. I'd kind of like to emphasize for a second, and I kind of got away from it at the beginning of when we were talking about that, was that the Anglo-American emphasis on individual rights and individual liberties is, I think, stronger than in other cultures, and the American knee-jerk reaction is always to sue. And we have that, and it's very hard when we talk about community to expect Americans to give up their personal rights to join that community.
Yes.
That's what we find to be the problem.
And it seems that stemming back from ages ago, we're finding new ways to feel insulted or put upon by other people. A fairly recent cause of action has been intentional infliction of emotional distress. And that sounds like very modern thinking compared to trespass or battery. Can you explain a little bit about what that exactly is and maybe give us an example of the kind of case that is brought in for this action?
Intentional infliction of emotional distress developed in the 20th century as a tort, and it occurs when someone acts in such an outrageous way that the sort of traditional way of stating it is that when you hear the facts of the case, you say to yourself, outrageous. So they act so outrageously that they cause not just sort of a minor annoyance to the person who has to live with their action, but severe emotional distress, often to the point of physical manifestation of that distress. And we do talk about some examples in the book of cases where that tort was used. One involved a case of a county commissioner speaking to a county employee and calling him by a horrible racial epithet, a terrible name, in front of a lot of other people in a very condescending and cruel way. The employee sued for the tort of intentional infliction of emotional distress and survived the initial stage of the lawsuit so that he would have been allowed to move forward had the case not settled, which was ultimately what happened. Now, one of the things we did when we were researching the book was talk to some of the counsel who worked on these cases, and the lawyer in that particular case thought that the whole case perhaps could have gone away at the very beginning if the person who spoke this horrible, rude, insulting term would simply have apologized. And a number of counsel told us that if they just had an apology at the beginning, you know what, we wouldn't have had to live through all of the time and the effort and the energy that went into the lawsuit. But somehow that doesn't happen in a lot of these cases.
In the case that you describe, in the principle that you say of outrageousness, it does seem that some sort of remedy should be there if that apology isn't forthcoming. Do you think that given the litigious nature of our society, though, that people will bring suits for emotional distress because they were told there wasn't any room in the movie theater for them, or they're too fat to get on an airplane, things of this nature that are happening?
I think the best example that I've seen most recently was one that I really hope that they'd continue with, because I wanted to call the lawyer and ask him what he was thinking. And that was his client was I believe it was in Tennessee, sued CBS and everybody else involved over Janet Jackson and the Super Bowl.
Oh, yes.
And one of the claims in that suit was outrage, that she had been suffered great humiliation due to this outrage and
of the costume malfunction.
The costume malfunction, right? And then I believe that when the media involved made their apologies, that finally they dropped the suit. And in a perverse way, I was a little disappointed because I was hoping that would go forward, because it seemed to me kind of a silly kind of lawsuit, frankly.
Well, that brings up another issue. In the book, you discuss the difference in offense, as it were, between actions and words or symbols. And as we discuss the high value placed on individual rights in our society, it seems to me there would be that distinction drawn there as well, that you theoretically would have a tougher time proving an injury just by words. Is that the case, or is it not?
No, that's definitely the case. When it comes to regulating speech and how people communicate with each other, American society has a lot of interest and a very strong interest in allowing the free communication and the free exchange of ideas. So unless, in general, the government then won't prohibit the way people speak to each other, and unless the type of speech falls into a very narrow kind of exception, for the most part, people are allowed to speak freely, and spoken words don't often constitute enough for either a civil or a criminal action.
Yeah, reading your book, I got the impression, I think it was actually stated a few times, that there's a certain amount of incivility that the government expects to happen and that we're all just going to have to put up with. Mm-hmm. It seems, though, that in other areas the government can get pretty specific about the kinds of things that shouldn't be said. For example, incivility in the context of sexual harassment has some very specific concerns around it. And I would imagine that it's much more heavily regulated by both law and by case law than other areas of speech. Are there particular areas in that are of concern today that we might want to talk about?
Well, that is an area of concern. Again, the government. I think in that case, in that situation, the government isn't concerned so much with freedom of speech, which is a very important concern, but more concerned with conditions in the workplace. And so we want to make sure that there is equality in the workplace and that people have the same terms and conditions of employment equally across genders and national origin and every other way in which we're not supposed to discriminate. So in that very narrow realm, one can make a case out because of the spoken word. But again, it has to be pretty severe before there's a remedy.
Okay. And that's still in that narrow area.
That's right.
It is. Yeah.
Okay. Can you tell me a little bit about what you found out about technology and civility? I mean, it seems that with the growth of the internet and electronic communications, that there's a whole new realm of rudeness out there that people are responding to. Is that easier to deal with or harder to deal with our mechanisms in society?
Well, we did find that this is sort of one of the examples of when you consider the question, has incivility gotten worse? You can see that it's a hard question to know the answer to, but one thing you can see is that the forms of incivility, as you said, have evolved, so that now we have things like cyber stalking or telephone abuse, where someone calls somebody else on the telephone over and over again, hundreds of times within a 24-hour period. Those are generally, in many cases, dealt with in the criminal law. So there are specific statutes often. Even with that, even when you have a written statute, it can be hard for those cases to be won by the government because of the fact that, again, to show a criminal offense and to prove a criminal offense, you have to meet a very high intent standard. And our government doesn't lightly convict people of offenses. So there are laws out there. There are well-drafted laws to deal with cyber stalking and other kinds of electronic abuse. But it isn't always easy to win those cases.
We also ought to note, too, that there's still that free speech problem, too, that the telephone abuse statute in in Massachusetts, for instance, says that your telephone harassment has to be solely to harass. So if you call up to harass but also express an opinion, maybe you're okay.
Huh, interesting. Now, we've given a litany of bad behaviors here and ways that people could be uncivil to each other. And in your book, you discuss some remedies for this, and one of the items that you bring up is etiquette and tradition as restraints or remedies to inappropriate behavior. Are these forces growing today or weakening? How would you see them in American society?
Well, etiquette certainly has its advocates. I mean, we have mismanners. We have mismanners like columnists. We have others, for example, Stephen Carter, who is a very well-known law professor from Yale, sort of argues on the basis of our historical community that we ought to follow tradition more in terms of respecting each other. We're all in favor of etiquette and tradition. It's just that it doesn't seem to be working. In the sense, our sense is that society is becoming more diverse, more spread out, less of a community, and less. People don't know as much about etiquette as they used to. People don't respect it as much as they used to. It's a great idea if it would work. It just doesn't seem to be doing the trick now.
Okay, so our rules of manners, our etiquette, our mores aren't clear enough in all of our minds to inhibit our behavior any. Are there any other, perhaps more formal communications that would work to serve to curb incivility, like mediation or something of that nature?
Well, there are several kinds of extra legal remedies that we found. The University of Pennsylvania enacted a speech code. They've since scrapped it, but there was because it frankly didn't work. But they did use a speech code for a while that made it an offense to use racially harmful language. Something that did work, we found, was the sexual offense prevention policy at Antioch College. That came out with some uproar when it first came out, and there was a claim that there were going to be kissing police, keeping people from doing what came naturally. But when we spoke to the people at Antioch, they said it works just great. The kids see it as a formal mechanism by which to manage mainly very bad situations, and that they follow the spirit but not necessarily the letter of the law. Mediation is something else, and that would be more after the fact, I guess. That's when something has happened. There's a large network of mediation programs and mediation companies that will handle this sort of thing. Whether it works or not, I think in many ways it's going to work better than litigation because it's cheaper, if nothing else, and people become less entrenched in it. It is a solution. It is something that people ought to pursue.
We've already mentioned here today, though, it seems that Americans love to litigate. You've looked at a lot of these cases. Can you think of one in which litigation actually worked? Or does it wind up costing as much as the original incivility cost you in peace of mind?
Well, there certainly are cases that you read and you come to the end of it and you think, thank goodness, the good guy won or the good woman won there. So it's nice to have litigation as a remedy, but and George and I are not litigators, but we've spent enough time with them to know and been around litigation enough to know that it's a dreadful process. I mean, it's terribly expensive. It's time-consuming. You have to involve a lot of lawyers. A lot of documents, it's a lot of trouble, and people get very emotionally attached to the outcome of litigation. If there's any way it can be avoided, it's much preferable to avoid it.
So if we can find another system of solving these problems of incivility between each other, then we could probably look for those. A question for you. This is a joint book. You've written it, your husband and wife. How did that process work? How did you manage to say civil to each other while you were writing the book, or did you?
Well, she's always right. That helps.
I am.
Well, I can see how that would work very clearly. And one last question for you. You've looked at a lot of cases of misbehavior about how people treat each other and how they've managed to treat each other, probably not as well as we would like to. Is there something that goes on in society today that's your particular pet peeve, a case of incivility that just sets you off, that you wish you could do something about with manners police or anything else? How about you, George?
I think I'll let George.
Nancy's much more easygoing than I am. I go from 0 to furious in about 5 seconds over things. People in parking lots. I think that's it. People should behave better in parking lots.
Okay.
Pulling out of spaces and pulling into spaces and pulling out of parking lots into traffic. That's what sets me off first. And
I personally would appreciate it if everyone would talk a little less loudly on their cell phone.
Oh, okay. Well, I'll have to watch that as we're going through it.
Yes.
And now we'll take a few questions from our audience.
I really enjoyed the discussion that we just had. I had a couple of related questions. I wanted to know what has been the reaction of trial lawyers to your book, and also given the fact that you've talked about some very litigious plaintiffs in your book, have any of them reacted? Have any of them tried to sue you as a result of what you've said?
Well, this is our second book, in fact, and the latter question is the one that's worried me the most. Our first book actually was about personal responsibility and people who refused to accept it, and we wrote about a lot of people in who brought lawsuits that where they weren't accepting personal responsibility, and I was afraid that they were exactly the kind of people who would come and sue us someday. But we haven't heard from anybody yet.
And we haven't, I don't think we've heard from any angry trial lawyers. We have heard from people who I think have a legitimate point of view, saying that you can't shuffle everything into mediation, into these informal dispute resolution processes, because sometimes you need a very public process depending on what the, particularly if there's a power differential between the parties. For example, you have a county employee and a county commissioner. Mediation maybe isn't the place to take care of that. You need a public forum where everybody knows what's happened. And so there's certainly, although litigation is a difficult thing for everybody, as we described, there's certainly a role for litigation and for trial lawyers, albeit a reduced number of them, I would say.
And my next question is, it sounds like your first book about personal responsibility has led you to your second book that we've been discussing today. And as a result of writing this book, do you have any plans for a third book?
Well, we actually do. We have thought about a third book. It's on a completely different subject that has nothing to do with personal responsibility or incivility, or maybe a lot to do with them. It's about law and baseball. But that's in the planning stages at the moment. So.
Thank you.
Good. How did you come up with the idea for the book? It's a very simple question, I know.
I'm not sure I remember. It's so long ago, and we went through so many cases. I think we really were just looking at the concept that has been current for a few years, that incivility was increasing. And we thought it would be fun to look at some of those cases. And then it began to strike us that whether incivility was increasing was actually a good question because of the very old nature of the torts, and that those torts did condone a certain amount of incivility and expect a certain amount of incivility. So that's really the basic kernel that the idea grew out of.
Found it probably more to be a serious matter than first thought?
Well, the cases are always pretty serious. I mean, there's some pretty nasty things that happen to these people in the books.
But we certainly found it to have a more extensive and detailed history than we ever realized. The history of incivility, as shown through lawsuits, is quite long and detailed.
Thank you.
Thank you.
Well, I must say, this has been very educational. I've really enjoyed it. We're glad to have had you here. Is there any one last little message that you would want to give people to this, on a little piece of advice on how they can get along with each other?
I think my final piece of advice to everyone would be apologize. Don't take things too hard if you don't have to, and see if you can diffuse a situation very early on.
Okay, so the sooner the better that we intervene in these cases of incivility, the less likely perhaps it's going to be that we'll escalate to this point where we need something like litigation.
That's right.
So you'd like to put some of your colleagues have a little less work on the court docket for these kind of cases that we can handle.
We'll find other work for them to do.
Yeah.
Well, thank you. And the last thing I'll tell you is that I want to make sure that I was civil to you today. We hope that you had a good time here. We really enjoyed your being here on Books at the Berkshire. Thank you very much, George.
Thank you very much, Walter. We enjoyed it.
Thank you very much, Nancy.
Thank you, Walter.
You've been watching Books at the Berkshire. Our guests have been George Jarecke and Nancy Plant. Their new book is Seeking Civility, Common Courtesy, and the Common Law. If you would like additional information about this book discussed today, this program, or any of the programs on SCCtv, please visit our website at www.scctv.net. Thank you for joining us. We'll see you next time.
This program was produced by SCCtv, Seattle Community Colleges Television, the face and voice of the Seattle Community Colleges, serving 55,000 students at 4 campuses and 5 learning centers. The affordable gateway to higher education.